Welcome to another episode of the Profitable Home Services Podcast. Once again, I'm so glad you chose to join us today. We've got another riveting episode coming up for you. We had such a good response to our previous episode with Philip Siegel that we brought him back to do a part two. Now, for those of you who maybe didn't catch part one, he is an employment attorney and he's going to continue to share some things that'll help keep us out of hot water. And then, of course, we will always at the very end, we'll discuss another hidden profit leak. So, buckle up, hold on tight, and we're going to jump back into the world of employment mistakes that's home service businesses as well as other businesses make. So, with that, welcome, Philip.
Diane, thank you for having me. I'm very much looking forward to helping your audience achieve success, keep their business running and their assets at home.
Keep themselves out of trouble, right?
Happy to do it. Keeps me busy. But this is all about avoiding trouble.
Avoiding trouble. You're right. So they don't have to knock at your door and say, Philip, help.
Diane, actually, a lot of our practice is built on being on the front end, preventive.
Okay.
A lot of the home improvement contractors, our bread and butter clients, they're not building budgets and anticipating litigation. They don't have litigation budgets. They're primarily family-owned businesses, sophisticated, but really are about making money and getting the work done. And, these are issues that come up and take away from that. And we're all about addressing these things on the front end to avoid, having to address it in a much more expensive way, taking away from your ability to make a profit on the back end.
I remember one of the comments you made on the previous episode was that attorneys were never opposed to billing $50,000 to keep from paying a $10,000, fine or penalty or something. And that really stuck with me of how fast those numbers can escalate.
Yeah, no doubt.
Yeah. So why don't we get started with talking a little bit about what happens when we fail to document disciplinary actions?
Yeah.
How much trouble can we get into for not keeping good records?
Really, this is probably, there are, among the mistakes we've already covered, there are bigger mistakes you can make that have significant or more significant legal consequences. This mistake, though, in my experience, is the most frustrating mistake made by the contractor client. And that's because the mistake comes to light when you are consulting with an attorney about a potential termination. You are coming to the phone call wanting to terminate someone, and you're thinking, your listeners, Diane, are thinking, I just need to dot I's and cross T's. This person is, not doing a good job. I want to call our attorney. I want to just get the attorney's blessing that, hey, you can certainly proceed with that termination. You don't have to worry about any discrimination claim. And that's really what I'm concerned about. But it's frustrating for that customer or that contractor, home improvement contractor that calls, because inevitably the first question I ask is, all right, have any of these performance issues been documented? Is the employee, if you're going to meet with that employee tomorrow to communicate the termination, is the employee going to be surprised? We want to avoid surprised employees. Surprised employees tend to think that they've been the victim of illegal activity, discriminated against. If it's an individual in a protected category, and they're surprised and they've got no prior warning, they'll think it's discriminatory. They're going to run to the Equal Employment Opportunity Commission, the EEOC, or if your listeners sit in a state that has a state agency that does the equivalent work of the EEOC, the employee will file a charge of discrimination. And the investigator that gets that file, Diane, doesn't know either party. They don't know the claimant from a hole in the wall, and they don't know the company from a hole in the wall. Neither side has earned any credibility. But despite not knowing anybody, in my experience, now approaching almost 30 years, these investigators tend to side with the employee out of the chute, looking to lend a helping hand to the employee. And if the employer is unable to produce any documentation showing the employee was warned and told if things didn't improve, there's going to be a termination, you're going to lose your job, the investigator, at least at this stage of these proceedings, tends to think it's a credibility issue. That, is the company really, was there really a work performance issue? Why are there no documents indicating this person was met with, it was discussed, they weren't put on a performance improvement plan, that kind of thing. So the mistake is in not meeting with the employee as these issues arise, whether it's a disciplinary issue. And listen, there are some disciplinary issues that call for immediate termination. Yeah. You've got people stealing from you or fighting in the warehouse and it's on video. Both examples of matters I've handled. Those would, you've got the evidence, you've got the video, and you've got proof they've stolen something. You can jump right to termination. I'm really more concerned about the incidences or the ability to perform the job that don't necessarily rise to the level of immediate termination. And the mistake is made in not consulting with those employees in real time as the issue is happening. And to go a step further, it's not just meeting with the employee. And Diane, these are a couple important points I'm going to make for your listeners. Number one, when you meet with the employee, there need to be two people from management in on that interview. One person from management is doing the talking. The second person is doing nothing but taking notes as the conversation is occurring. And that's really important because it's those notes that we would attach as an exhibit to a response to a charge of discrimination to tell the investigator, well, wait a minute, this person did get a warning. We met with them. Here are the notes from that meeting. And, by the way, at the end of that meeting, here's the second important point for your listeners. You have to present those notes to the employee who has just been counseled. And you're asking that employee to review the notes and to initial and date the notes as accurate. If the employee wants, we need to have the employee acknowledge that the notes accurately reflect what was discussed. If the employee wants to argue about whether their performance was poor or whether they did what they're alleged to have done, you can listen to those arguments. You can choose to put them in the notes. Most companies don't. If the employee wants to create their own written complaint with that kind of things, we'll take it. But we just want the employee not to admit if they're not willing to make an admission. We're not asking them to admit. We just want them to, what we're only asking them to admit is that the notes reflect what was discussed. Again, if they want to note their objection to what was discussed in terms of the merits, okay. I just want them to acknowledge the notes are accurate. And if they refuse to sign, then I'm instructing our clients to make a note that says employee was offered the opportunity to review, refused, and that's the note, the last note that you're left with. And the other hand, if the employee, I'm sorry, Dan, go ahead.
I'm going to guess, out of all the home service businesses that I work with, what percentage do you think are doing all these steps?
I don't mean any disrespect to your listeners, but this is the kind of thing that keeps me busy, Diane, and it's
be like
why
0
we're talking about
or 1.
It's one of my top 10 mistakes because I can joke loosely that everybody's making this mistake. I mean, the companies that aren't making this mistake are the ones that have already called me, and I've had to tell them, hey, listen, I know you were planning to terminate this guy this afternoon, but you got to pump the brakes. Instead, this afternoon, you need to meet with him, the two members of management, and you have to have the meeting I just got done walking you through.
Wow.
And, you hope things improve, but if they don't, you're coming back to that person, however long it takes. Is 2 weeks enough time? It depends on what the issues are. I tend to push clients to at least 30 days. But if things haven't improved, and of course, we end that first meeting with, like, we hope things improve. We hope you get the message because we're being very clear as that meeting concludes that if things do not improve, you're going to lose your job. And the notes reflect that warning. And then, 30 days later, if things haven't improved, we're calling the employee and like, hey, we met a month ago. It's been a month. You've had a month to improve. We're not seeing any improvement. You've continued to make these mistakes. You're not performing as efficiently as we require. I'm sorry, but we're going to have to terminate your employment. And I feel a lot better with the client that calls me and I ask them, well, have you met with the employee and documented it? Yes, we have. All right, send me what that looks like. It may be a disciplinary record. ideally, again, I want the notes that flow from the meeting because I'm looking for that last notation that says the employee was warned that they were going to lose their job. Again, I'm
Okay.
looking to avoid the surprised employee down the road. And if that client calls me and they've already checked these boxes, well then, Diane, unless there's something like a recent protected activity that is thrown a wrench into things, I'm blessing that termination. They'll have done everything I would have advised them to do. They will have already done that. And again, the key is the meeting minutes and letting me look at those notes, making sure it's clear the employee was told they were going to be terminated. And again, I'm either looking for the employee's initials with the date or the employee's note that says the employer's note that says the employee refused to sign.
Right.
But
So
you've done that, and then I'm blessing the termination, and you're moving forward. Otherwise, again, I said it's frustrating because a lot of these companies have to pump the brakes, and things get pushed 30 days, and more often than not, things don't improve, and that 30-day period is a rough one. On the
well,
other
Phil,
hand, where they do improve, that's great for everybody, and the
right.
company's really happy they did it that way.
So we hear all the time the phrase that says slow to hire, quick to fire. Doesn't sound like that really works in the perfect situation.
Well, I think that's good advice. I mean, you talk about profit leaks. I mean, keeping people who are not performing well on payroll and not doing anything about it, that's a big problem,
Huge
especially if
profit.
the issue is one of safety. I mean, geez, those people can cost you big time and shut your company down with
Hmm.
just one wrong move. And but sticking with that person who's not being safe, it's about documenting um, the unsafe activity as a disciplinary issue, and to tell that person at some point, the next one, zero tolerance going forward, you're going to be terminated. The key is to tie into that phrase you used, Diane. Slow to hire, quick to fire. I get that, but we need to make sure we're taking the right steps before we actually pull the trigger on firing. I mean, listen, I've had clients call me. Someone interviews well, the resume looks great, we got good references. We're a few days in, and they're already calling me, asking me, we'd like to terminate this person. They're doing awful, or what? I'm pumping the brakes on that. I still think we
Oh,
need to have
wow.
the meeting. Every scenario presents differently, but to that point, you know, don't let things fester. I mean, each of those companies that call me and say, "Hey, we want to terminate him this afternoon," no, we haven't met with them. They were worried about feelings getting hurt. I mean, you know, it's not the time to be Mr. Nice Guy. You have to put all that to the side. Listen, I mean, I'm running a business here. We have a good culture. I'm not trying to pat myself on the back here, but the point I'm making is we've had to terminate people that we've really liked, but that's because they haven't been performing. And before we get to the termination meeting, which actually is easy, the harder one is the meeting where we're telling them you're not doing a good job and things need to improve.
That's
And
a
I
painful
lose
meeting.
sleep on about those meetings the night before. I get it; it's easier said than done, but you gotta set it aside, and you ultimately have to remember we have a business to run, and this person is affecting our bottom line and ability to run efficiently and
I,
profitably, and you just got to take the gloves off and get
yeah,
it done. You can do
I
it for
remember.
you have to be firm, but you have to be professional as well, and you have to do it.
I remember several years ago, I had an admin assistant who wasn't working out. So I sat down with her and we had that first conversation. We laid out a performance improvement plan. Unfortunately, we kept trying for like 90 days. Every 30 days we were meeting. It was getting worse, not better. And then I finally let her go and she was so surprised, thinking, what do you think we've been doing for the last few months? Trying and trying and trying to get you to improve and you didn't. So, yeah, we have to go our separate ways. I like you as a person, but you're not a good fit in my company and you're bleeding my profits out, right and left.
Well said, and that's really good way to
But
communicate.
I was surprised that she was shocked that when I finally let her go
Well,
after that long
you'll
of a
have that.
period.
Yeah, that of course still happens.
Yeah.
But I don't buy it. I mean, when we've had the meeting and it's the notes are accurate and thorough, and we've checked the box on making sure we warned that the employee's position is at stake. There's nothing left to do.
So, question for you. You said we need two members of management. In today's world, could we have something like Otter or some other AI on our phone transcribing the meeting? Does
Hmm.
that count as a second person?
I think that would work. It's interesting. I didn't consider that, but that's certainly 2025 right there for you, Diane. The key is going to be, are the notes accurate? In my experience, in most cases they are, almost all cases, and um, printing those notes. In that case, we'd want to make sure as the employer we're reviewing them as well,
Mhm.
and noting they're accurate as well because we didn't draft them.
Right, because
But
you could get
at the end of the day,
a
if the notes
summary.
are, I'm sorry, Dan.
Because it'll produce a summary for you, and then you go through and make sure that it's accurate.
Yeah, and you
But
want to
that
make sure
could work.
again, we
Okay.
want to make sure it's thorough and
Right.
accurate. But if it is thorough and accurate, then we're printing it and we're presenting it to the employee to initial and date as if it was, someone in the room actually taking the notes as the
Okay.
meeting was being held. It's not mandatory that a human being takes those notes. What's most
Okay.
important is that notes are taken, they're accurate, and the employee has acknowledged their existence and their
Okay.
accuracy.
Right. Because sometimes that helps, especially in the case of a smaller company. You may not have a second person
Yeah,
available
good
to
point.
do that type of thing. So that could
Yeah,
become
and
your second person.
and I get clients asking me, well, what about recording the meeting? Well, the thing about recording the meeting, yeah, you think that's a great idea. One, you need to make sure, are you in a state that, if are you secretly recording it? Are you in a one-party consent state? If not, you need to have the other person's consent to the recording. And um, I just caution companies about jumping right to recording it because sometimes, especially where the employee knows it's being recorded, they tend to clam up and not be as forthcoming,
Right.
knowing it's being recorded. So I get that it has benefits, but I want people to recognize it's a double-edged sword there.
Right. Yeah. But if you don't have that second person, you could come up with a little bit out of the box way of getting that accomplished.
100%.
Yeah.
Again, what's most important is that orally, the employee was told you have an issue, and if there's no improvement, you're going to be terminated. Number two, the notes, however they're created, reflect that. And then again, a hard copy is printed. The employee has the opportunity to review. And then, by the way, Diane, if they want to make corrections, if they don't think the notes are accurate, you should tell the employee, tell me where you don't think the notes are accurate, and then discuss it. And if we agree, oh yeah, that was something we discussed, the notes don't reflect it, then add it in.
You bet.
Otherwise, your listeners should say to the employee, I don't think that's what we discussed, but if you want to create a second memo, I'm happy to take it from you and put it in the file. And just note that one exception on the memo.
Right. Okay. Well, let's move on to mistake number 5, which is failing to obtain a release or severance agreement from a terminated employee. Unpack that one for us, if you would.
Yeah, well, we're bleeding right into it because here we've done everything right. Consider our last mistake. We've done everything right. While we were discussing that, Dan, I kind of threw in there in passing, we do need to consider whether the employee is engaged in any recent protected conduct, made a complaint about a safety issue
Oh,
or a
okay.
wage and hour issue. But let's set that aside. If you've called me to pick up where we left and you're looking to terminate someone, and I'm asking you whether you have made the mistake we just got done walking through, and you tell me, no, that's not a mistake made. We met with the employee. We actually met with the employee twice. Things did not improve. We can show you mistakes and errors that were made. The point I'm making is this client is in a position where they're ready to terminate this employee, and they've checked all of my boxes. Now I'm
Okay.
asking, and I want to be clear. We unquestionably have grounds to terminate. I'm not worried about any discrimination claim. Yet, either the employee is in a protected category, or and has made some comment that they feel that the victim of discrimination, or they've engaged in some recent protected activity. Now, none of that absolves them of having to meet company performance standards and keep out of disciplinary issues. Yet, when we have this phone call, and I am blessing the termination, but we consider recent activity and whether the individual is in a protected category, it would be a mistake not to consider whether to offer severance pay in exchange for a release of claims. Now, let me explain that. There, again, like the fight in the warehouse or stealing from the company, where we've got video evidence or hard proof that things have happened like this, we're not going to pay severance to someone that has done something so egregious. I'm dabbling more in the gray area where the termination decision involves some judgment call. And nobody is going to interfere, no one is going to interfere with the judgment of the company as long as that judgment is exercised in good faith and it's not discriminatory. So we want to make sure that as we're proceeding with the termination, we're looking to put an end to it. So the most egregious cases, we're not going to pay severance. That gray area, that's a situation where, despite, again, you've consulted with me, I am confident there's no grounds for discrimination claim, yet we're recognizing the situation, protected activity, maybe protected category, we're offering some money in exchange for release of claims. And really at that point, it's just to help you sleep better. And I'm not saying that lightly or to be funny about it, because again, a point I've made a couple times already, we're confident if this person runs to file a charge of discrimination, even though that investigator doesn't know either of us, I mean, we've got a lot to lay on that investigator. There's no way the EEOC is going to find any cause. So we're hoping the employee signs the agreement and we're done with it. How much needs to be paid is going to be dependent on what the company is willing to pay. It's not open for negotiation. I mean, If the employee, Diane, if the employee refuses to sign this agreement, then you can anticipate they are going to, logically, they would be filing a charge of discrimination. And we will have already covered that contingency when we made the decision to proceed with the termination. We'll have already covered the possibility that this person won't sign the agreement and they'll file a charge of discrimination. On the other hand, if they do sign the agreement, then it's all over and you're done and you don't have to worry about the filing a claim. A couple extra points though. A sub mistake here involves those companies that know to get a release or offer severance in exchange for release of claims, and the employee that they're going to be terminated happens to be at least 40 years old, and these companies are pulling separation agreements or termination agreements or severance agreements off of the internet. They seem to be pretty thorough. They're printing them up. They're having the employee sign it who's 40 years old or older. They're paying the severance payment. And then weeks later, this individual who you think you got a release of claims from and you paid for it files a charge of discrimination alleging they were the victim of age discrimination in employment. Age discrimination, ADEA. And that company calls their attorney and says, well, wait a minute, this person released their claims against us. We paid them severance. Here's a copy of the release. Well, the attorney who knows the law is looking for two key provisions in that scenario where we're dealing with someone who's at least 40 years old. Number one, does the agreement include a provision that expressly allows the employee up to 21 days to review the agreement? And then number two, is there a provision that expressly informs the employee that they have 7 days after signing the agreement to revoke their signature and identify where they are to send that revocation? Because those two key provisions are required to effectuate a release of age discrimination and Employment Act claims. So the mistake is, one, not considering, again, I want to be clear, we've got grounds to terminate. We're focusing now on whether the employee engaged in any recent activity or is in a protected category. If so, don't make the mistake of not considering offering severance. Again, the egregious cases I'm not talking about. I'm talking about cases where some cowboy EEOC investigator may 1% chance think that there's some, smoke leading to a fire that gives this charge of discrimination credibility. It happens, even in those cases where we think it's completely frivolous. And again, it's those frivolous cases where we're deciding to terminate because we're recognizing the employee can refuse to sign the agreement. And again, we can anticipate that charge and we already know what our response is going to be. It's everything we told the employee in the warning meetings and in the termination meeting itself.
So Philip, would you hold off on the severance pay until that 7 days has gone past, or?
Absolutely. Yeah, Diane, great point. Thank you for making it. We do want to make sure that agreement, you've got the two terms I just noted. You don't want to be, your payment provision needs to, mine typically says the severance pay is due on the first regular payday following expiration of the revocation period. You can do it a couple of different ways. You can say a week after the revocation period expires. The bottom line, to your point, Diane, the agreement needs to provide that payment isn't due until after the revocation period expires. I do want to add one bonus point to your listeners. We're talking, I said in both these mistakes we've covered, I've mentioned charges of discrimination. I do want to let your listeners know there is insurance also that provides protection for these kinds of claims. In the industry, the acronym is EPLI. It's Employment Practices Liability Insurance. Not terribly expensive. The guys that sell it refer to as sleep insurance, like I refer to the agreement as sleep insurance. It just covers these claims without, it's insurance for these types of claims. I will, to add some dollars and cents to this, Diane, if a charge of discrimination is filed in one of these cases where we've already decided we had legit grounds to terminate, preparing that position statement where we've gotten the exhibits, because again, we had all this in order before we actually went into the termination meeting, typically runs between $2,500 to $5,000, depending on how many allegations are actually in the charge. So that sometimes helps companies dictate how much severance do we want to offer. Other factors that companies look at, I'm telling your listeners what they already know, typically length of employment. And, again, what activity or what category is out there that is even making us think we should offer the agreement.
Wow, there is a lot for a home service business owner to be thinking about, especially if they have a smaller team and they're growing and that team is starting to grow. And now we got to be thinking about more of these things than we were maybe a few years ago.
No question about it. It's, 15 employees is going to be the trigger. And I know a lot of these home service companies engage people as independent contractors. Well, if the law determines those independent contractors are misclassified, something we spoke about last time, Diane, then they're going to be under the law employees that may put your listeners over the 15 number threshold. Then they need to be concerned about these claims. And I'll add more to it. I mean, if let me first say, we're offering the severance agreement to nip it in the bud right at the termination or potentially up to 21 days after. The individual who refuses to sign the agreement and thinks they've got a discrimination claim has up to 6 months, 180 days to bring that claim. So it's lurking out there until you get to the expiration of that 180-day period. Again, creating incentive for you to at least entertain the idea of offering severance in exchange for a release of claims.
So when you said, was it 50, like in 50 days, or 50?
The number of employees is 15.
15, 15, not 50. Okay. So 15, that encompasses a lot of the home service businesses out there.
Yeah. Well, that's the threshold. And while we're talking about this topic, it's not one of these mistakes, but you ought to have an EEO policy. These companies that are over 15, if you've got nothing else, a harassment and discrimination policy as well.
Wow. There is a lot to being an employer.
In construction, absolutely, especially in construction, workforces tend to be fluid and creating these types of problems.
Right. Wow. Okay. Thank you for unpacking both of those areas of big mistakes. Let's switch gears again, and this time let's talk about the dreaded OSHA inspection and what happens
Yeah.
if you're not, maybe you've never encountered that before, so you may not be ready for it. How does that work its way into a home service business?
Yeah. Well, the trades that most need to be concerned about OSHA when we're talking about home service trades are those that work outdoors and in plain view. Warehouse work also is potentially, on the list of likely targets for OSHA. But too many times, in representing the home improvement contractor, they more often than not, when I'm getting a call and they're having an experience with OSHA, it's their first experience,
Right.
and they haven't. And we're talking about this now because um, contractors that don't understand their rights when subject to an OSHA inspection often end up doing things just in the first hour of OSHA arriving on site that end up making the case unwinnable. And a couple important points I want to make sure your listeners understand as employers in the home improvement business. One, if OSHA shows up on any work site or in your office, one person should be assigned the task of being the company's representative in dealing with OSHA. So if OSHA shows up on a work site and that person who's assigned the task and has had the training and knows the employer's rights in an OSHA inspection, if that person's not present, the person who is first approached by OSHA needs to be trained to tell the OSHA compliance officer, my job if OSHA shows up is to call the office and to get our safety guy, whoever, whatever the job title is, out to the job site to be the company's eyes, ears, and front person as you conduct the inspection. OSHA, we intend to cooperate with you. I just am told if this happens, I need to call the office and we need to get the person whose responsibility is to interact with you out here at this job site. Now, OSHA compliance officers will wait up to an hour for that person to show up,
Okay.
according to their own field operations manual. That's number one, because typically that first person who OSHA approaches, or when OSHA shows up, they're asking around. They're like, who's in charge around here? And the person who's in charge, as is pointed out to the compliance officer, for the purposes of our discussion, Diane, that's a supervisory employee. The person who's in charge, when they speak, it's as if the company is talking.
Correct. Right.
And that's a really important point because, and why we're talking about it, most contractors don't recognize that. And they allow their supervisors, and this is really the biggest mistake within this mistake, they allow their supervisors to meet with OSHA without any company representative present, including the company attorney. A supervisory employee should never be permitted to interview with OSHA unless, one, they've been prepped and they prepared for that interview with a safety consultant or with an attorney that knows how these interviews go. And then number two, we want to make sure that, in the actual interview, that they're accompanied by that company representative, including potentially the company attorney. And then to go a step further, companies need to know that the supervisory employees are never going to be obligated or required to sign a statement that OSHA's written for them. And that, again, is an important point lost on the company that's never been subject to an OSHA inspection, because to go to the point I made a few minutes earlier, losing the case and making it unwinnable in the first hour, the compliance officer gets to your supervisor, gets the supervisor to make a series of admissions. The compliance officer is taking these admissions down in narrative note-taking format. They're handing the notes to the supervisor. They're asking the employee to review the notes and to sign off on the statement as if it was the supervisor's own statement, with
Wow.
admissions and everything. Well, Diane, that case becomes unwinnable. And the mistake is in not knowing what your rights are during an OSHA inspection. Now, I've talked a lot right here just about the supervisory employee. What about the non-supervisor? Well, the non-supervisor, they're not speaking on behalf of the company. Again, the company talks through its supervisory employees, but the non-supervisors are potential witnesses at a hearing. Again, what they say doesn't bind the company. OSHA gets to interview those people as well, and the company does not get to participate. Those interviews are considered privileged. If the employee wants their own representative present, they can have that person there. It's not going to be the company attorney, though. That would potentially create a conflict of interest. In any event, how do you deal with OSHA interviewing your non-supervisory employee without anybody there with the non-supervisor? Well, I've got a couple points for your listeners to take home. Number one, if OSHA's out on your work site, ideally you would like to get to the non-supervisors before OSHA does. Asking what happened, and beyond getting beyond what happened, we also are using that opportunity to refresh their recollection on what training they've been given and whether they've been subject to safety inspection. We want these things fresh in their head, because then when we're done with them, and we've taken notes in that meeting, we've taken notes, and we're having the employee sign the notes. It's not the disciplinary interview. We're asking the employee, and maybe even we want the employee to write out their own statement. In any event, we're getting in with them before OSHA does. Because what typically happens is OSHA then meets with these non-supervisors, and OSHA's presence can be intimidating with a non-supervisor, perhaps, especially with someone who speaks English as a second language. Because these people, compliance officers, show up with badges, and in my experience, these employees, they tend to really say anything just to get through it and get done with it. They're so uncomfortable and intimidated. And again, they're not obligated to sign any statement. They can't be required to sign any statement. You have to communicate to your employees through training that they don't have to sign any statement that OSHA presents. But again, these people get intimidated. They want to get out of there. The compliance officer isn't telling them you don't have to sign. And they're shoving it in front of their face, and these guys are signing it. And although it may not be an admission that binds the company, those statements tend to have testimony that would hurt the company. And we have to begin building our rebuttal case. After that non-supervisor meets with OSHA, we want to get them a second time. And if we weren't able to get to them beforehand, then we're getting them with them after they've met with OSHA for the first time. In that interview, we're making sure we tell the employee, hey, you're not going to be penalized or disciplined for anything you tell us. We just want to make sure that you gave accurate and thorough information to the compliance officer. And in this follow-up interview, for lack of a better term, we're doing exactly what I just said. We're making sure that the non-supervisor gave thorough and accurate responses. And where we learned that they didn't, we're quick to get back with the compliance officer and say, hey, listen, we met with Al. Al told us he told you he got no training, but Al forgot that he did receive training on fall protection and ladder setup, and here are the documents that show you he did. He just got nervous meeting with you. He's never met with a government employee before, and we have Al, who's written the statement confirming that he did get this training, and these are his signatures on the attendance sheets. That's the best you can do with the non-supervisor. But really, Diane, the more damning issue is the company that doesn't realize they have rights. For example, telling the compliance officer, we are going to make our supervisors available to you. You just are going to have to schedule those interviews through our safety consultant, outside attorney, whatever. Here's the contact information for those people. Let us know which supervisors you want to interview, and we'll make them available. And then again, in the time leading up to that interview with OSHA, if you've called me, I'm meeting with the supervisor. I'm preparing them for that interview. We're covering the most difficult questions we anticipate being asked. and the supervisor is going in there having been trained a little bit, ready for some of the questions, and again, knowing at the end they're going to refuse to sign any statement. That's typically something I cover in the front end if I'm there. And we're trying to remain cooperative and friendly the entire time at this point. So I'm telling the compliance officer, hey, I won't be interrupting you. It's not a deposition. It's not like I can object. I'm really there to make sure people aren't talking over each other and understanding each other. But otherwise, I tell the compliance officer, listen, I don't want to be the bad guy, but I got to tell you, I came up under an attorney 30 years ago who told our clients never to sign these statements, and I've just lived by that. So I don't want to get off on the wrong foot, but Mr. or Miss Compliance Officer, John here isn't going to be signing any statements today. They're okay. That's it. They move on. They're taking notes. They're transcribing everything that was said. We're just not signing off on it.
Right. Okay. Wow. I am fortunate that I've not had to walk through that with any of my clients or anything. So
no, it
fortunate.
gets really rough. That's a really bad mistake, Diane, because OSHA, like the discrimination claim, federal OSHA has up to 6 months to issue that citation.
Wow.
And sometimes, we don't know that our supervisors have signed damning statements until after the citation is issued, and we've got a game plan to take into what's called the informal conference. We're sitting in that informal conference thinking we've got a great case. Then the compliance officer shows up, they slap a file on the desk, and the first document out of the file is the supervisor's written statement, initialed and signed, and we read through it. Says I didn't get any training, there were no inspections, and I don't know why our guys weren't tied off.
Wow. So coming from a person who doesn't actually work out in that world, what prompts an OSHA investigation? Is it just luck of the draw? Or
no, the two most common is the plain view. You got a trade contractor, home improvement contractor outside doing work, and the compliance officer, just bad luck, happens to drive by and sees an issue and stops. The other common scenario involves the disgruntled employee that has made an anonymous complaint to OSHA. Those are the two most common. Let me stop there.
Yeah. Okay.
You'll have also, if you're working outside and someone, listen, this is crazy, Diane. I've had the OSHA case, home improvement contractor, happened to have been a residential roofing contractor. It was in, of course, a subdivision, and you had some snooping neighbor walking their dog. They actually took pictures of the trade contractor up on the roof not being tied off. So they send the pictures to OSHA. And OSHA never even conducts an investigation. We get the citation in the mail. It's the first we heard of it. They got their witness. That's all they needed was that homeowner. We got out of that we had a strong defense there. But, it can happen like that too. You're doing work across the street from someone who's being nosy. They're a potential rat on you.
Wow. So it could come pretty much out of the blue.
Come out of the blue. And that's typically how it does happen. Of course, if there's a third scenario, it's where, unfortunately, the contractor has suffered some significant injury or potentially worst case of fatality that mandates the company reporting it to OSHA.
Okay. But I would think the other two is probably more common.
Yeah, yes. But unfortunately, accidents happen, and if it involves a fatality or people going to the hospital for an inpatient stay, those trigger reporting obligation.
Right. Well, Philip, we've come to the point where it's time to talk about that hidden profit leak. So let me drop some money in our bucket. Let's talk about a hidden or unique profit leak that may be tied to one of these topics we've talked about today.
I got one. A light bulb just went off in my head. I'll give you the easy one. It's tied to all three of these. It's the profit leak is not terminating the individual who's proven to be unsafe. I'm not suggesting that you have a zero tolerance policy. I understand to get labor in construction is tough.
It is.
But the person who is repeatedly unsafe is going to cost you more in the long run. Either inevitably there will be an OSHA issue, or worse, God forbid, someone ends up getting hurt or killed. And the company that doesn't follow up with disciplinary documentation with the individual that's been unsafe, and then the company encounters one of those worst case scenarios, and you either have an attorney for the government in an OSHA scenario, or a plaintiff's attorney prosecuting a wrongful death case, pointing to your customer, your listener, Diane, and saying, Your Honor, or jury, my friends, what do you got to do to get fired over there? That's the worst. I mean,
Oh my goodness.
I can't take credit for that. I actually sat through that, and it was cringeworthy. Because that kind of thing resonates with people's emotions. And again, if you're not terminating people who are not being safe, that is a potential significant profit leak.
Wow. Thank you so much for sharing that one with us. Listeners, be listening, paying attention to this. There will be show notes. This is one that's very noteworthy, and you may want to come back and listen to it again, as well as part one when we had Philip with us not too long ago. So go back and find that one as well. Philip, thank you again for coming and talking to us, scaring us all now that we gotta go out and make sure we get some of these things tightened up in our businesses. How
Really do
can
welcome the opportunity, Diane. And you joke, but I get that joke a lot. If I've made anybody nervous on this, let me just throw out my number there to be available to
you
assuage
bet?
these concerns. Our office number is 404-522-1410. And I'm happy to take an initial call from any of your listeners that heard the show, and maybe they're feeling uneasy right now. That wasn't my intention, but maybe that's not such a bad thing.
I think it's not a bad thing when we become aware of something that we didn't, you know, we didn't know it yesterday, but now we know it today because we all live in the world if we don't know what we don't know. So thank you for opening eyes and bringing this important topics. These were really good ones, and I'm very thankful that you were able to spend time with us, especially to do two parts to this because we just knew we couldn't unpack it in one. It was too much.
Really happy to help again. This is blends well with our practice about getting it on the front end and avoiding these bigger problems.
You bet. Yeah. Thank you, listeners, for hanging on for this episode and all the others. We really appreciate you spending time out of your day with us. And just know that this podcast is available in all the normal podcast channels. It's also available out there on YouTube. We'd love for you to like and subscribe and help us boost our YouTube listeners, our YouTube channel. Thank you again. Have a great day, and we will catch you on the next episode of the Profitable Home Services Podcast. Bye, everybody.